So now I'm going to talk about how we handle a final restraining order, how it's resolved. So if you haven't seen my previous videos where I talked about the three different types of domestic violence cases, and where I talk about how to get a restraining order, a temporary restraining order, a TRO, I advise that you watch those videos. But in this video, it's basically talking about the permanent restraining order, and so some people call it a final restraining order because it can be final, it can be permanent on your record. So, as I discussed in the previous video, when the TRO, the temporary restraining order, is when it's generated, when the judge approves it, it gets served on the individual that is a defendant, right? And it tells them the date and time where they're going to come to the courthouse. It even tells them which courtroom number, right? They have to appear in order to have a trial. So the plaintiff comes and he or she states the narrative, proffers the evidence that they have to support. There are two elements that must be satisfied in order for the temporary restraining order to become a final restraining order. The two elements are: one, you must have what's called a predicate act. There must have been an act by the defendant, an act, right, that qualifies as a domestic violence act under the Domestic Violence Act in New Jersey. The official name of the act is called the Prevention of Domestic Violence Act. It was passed in 1991, but we call it the Domestic Violence Act for short. So on the Domestic Violence Act, there are a series of actions that qualify. They are categorized as domestic violence, whether it is stalking, harassment, threats, assault, kidnapping, etc. Right? And so there must be an act that meets the requirements, the definition of that action under the Domestic Violence Act. That's number one element. It's called a predicate act. The second element that's required in order to secure a final restraining order or a permanent restraining order is fear that, but for the restraining order, that action will continue. It will repeat itself in the future, right? Those are two elements. So one, predicate act, which I've explained, and two, there must be fear that if the judge does not issue this restraining order, this person will continue to do this. And usually the way that you can show that there's fear that it's going to continue is by your acts, right? Incidents that of such actions that have happened in the past, circumstances, things like that, right? It sounds easier than it actually is. I've seen cases where we're sitting in court, the individual comes in, gives the story, and the judge goes, no restraining order. Right? And of course, there are cases where it is granted, right? And so I advise that you secure the services of an attorney in the pursuit of a restraining order. Now, there is aside from trying the case, right, and there's direct examination, cross-examination, things like that, to either prove or disprove that a restraining order should happen, right? Aside from that process, there is also what's called a civil restraint. A civil restraint is basically a settlement of that restraining order case between the plaintiff and the defendant. Okay, the alleged victim and the alleged assailant. So in many cases, both parties will basically just have a negotiation, right? I've seen cases where one party says, "I want my cat," right? The other party says, "Well, I don't want you living in the house anymore. I want you to go." And so it is negotiated, right? But you're usually not able to negotiate that unless you have enough on the table where if you try the case, you may win or you may lose. That's where the leverage for negotiation comes from, right? And usually you need someone who has tried cases because it's always a trial. There's always a trial on a restraining order matter, right? So it is the evidence, it is the confidence to try the case, it is the finesse of the attorney handling these things. All these elements can play a part in both parties being able to negotiate what's called a civil restraint. Effectively, a civil restraint is also known as a consent order, right? Because both parties are negotiating something, and they basically consent to it, right? However, before the civil restraint is allowed by the court, once it's negotiated, the alleged victim will also see a counselor, right, at the courthouse, and this will make sure that the alleged victim is not being forced into the restraint, into the settlement. It's their free will. This is what they want to do, things like that. And once they're satisfied and they counsel on their rights and other resources, then we go before the judge. The judge reviews it, states it on the record in most cases, and at that point, if all the parties agree in front of the judge, it becomes a civil restraint. The restraining order matter is dismissed, right? It's dismissed, it's gone, and then the civil restraint order is how the matter is resolved. Both parties are expected and they're required to follow the civil restraint because it's actually an order from the court, right? And in cases where the parties do not honor the civil restraint, you can take additional legal action, such as motioning to force uh, to enforce litigants' rights, things like that, to force them to follow it. So these are the ways that a restraining order can be handled, whether through trial, win or lose, or through a civil restraint. This is attorney at Omojala Law. Hello, this is attorney Ade Omojala from Omojala Law, located right here in Jersey City, New Jersey. I have been practicing for over 14 years. I cover the areas of litigation, domestic violence, restraining orders, DUIs, driving under the influence, and also immigration. You can search Omojala Law into your favorite search engine. Just enter OMOJOLA space LAW, and it'll pull up our website, locations, and other information by which you can contact us. Again, this is Attorney Ade Omojola from Omojola Law, and I am looking forward to solving your legal problem.